the topic of my paper is developments in appropriate assessment, but in the time available, I really just want to focus in on one major development in the area of appropriate assessment that occurred this year. And for the purpose of my talk, what I'm proposing to do is to talk about a decision of the Court of Justice of the European Union in respect of a case referred by the Irish High Court. And that's the case of Friends of the Irish Environment versus On Board Pleanala. And what I propose to do is look firstly at the facts of the case before the High Court, why the High Court considered it was necessary to make a reference to the CJEU, the questions referred, and the ultimate decision of the court. So the particular facts of the case were that planning permission had been granted in 2008 for a liquefied natural gas regasification terminal, which was known as Shannon LNG. That permission had a lifespan of 10 years. And for those of you who will be familiar with the planning system in Ireland, you'll know that in general, the planning permission itself is for the implementation of that permission. So the permission had to be implemented within 10 years, i.e. the facility had to be built, but the 10 years didn't affect the actual lifespan of the operation of the facility once it had been built. So the 10 years was a construction 10 years, so to speak. While permission had been granted in 2008 with a lifespan of 10 years, no development works had actually commenced within that period. And in September 2017, the developer applied to alter the terms of the development, and that application was made under section 146B of the 2000 Act. And the application was actually to alter a condition of the planning permission, which imposed a 10-year lifespan. The application site itself didn't lie within a Natura 2000 site, but it was adjacent to 2 Natura 2000 sites. And when the board made its decision in March 2008, national law didn't transpose properly the habitats directives. And for those of you who will remember working in the area back in 2008, you'll recall that appropriate assessment was assimilated into the environmental impact assessment, which was carried out under the EIA directive. So there wasn't a separate appropriate assessment, and generally you would rarely see a decision which would actually refer to appropriate assessment or to the test under Article 6.3 of the Habitats Directive. And that procedure was condemned in the case Commission versus Ireland, case C41804. Now that judgment came out slightly before the decision of On Board Pleanala in March 2008 granting permission for the Shannon LNG facility. And because of that, obviously the board's decision didn't actually make any reference to the Habitats Directive. When the board granted consent to the developer to extend the life of the permission, a challenge was taken to that decision by the Friends of the Irish Environment. Now, numerous grounds of challenge were raised, but the one that I want to look at relates to the Habitats Directive. And that question was whether a decision to extend the duration of a permission engages the Habitats Directive. And as I said at the beginning, the application to extend was simply in respect of the period for construction. It didn't actually involve any physical how the actual construction take place. And that particular issue, i.e. the issue of whether or not an extension to the life of the permission triggered the Habitats Directive, had actually previously been considered by the Irish High Court in 2017 in the case of Merriman and Fingal County Council. And that decision related to an extension of the life of the permission up at Dublin Airport. And the High Court, Mr. Justice Barrett, ruled that the Habitats Directive didn't apply to a decision to grant an extension of the duration of the permission. And that judgment was, as I said, a 2017 judgment, and the Supreme Court had refused a leapfrog appeal to have this particular issue determined. So one would think that in 2019, when the Friends case came before the High Court and came before Mr. Justice Simons, that this issue was fairly clear, that there was no real issue in relation to the Habitats Directive and whether or not an extension of the life triggered the Habitats Directive. However, Mr. Justice Simons took a different view, and that was very much influenced by the fact that prior to his giving judgment and referring the Friends case to Europe, Advocate General Cocot's opinion in case C41117 had been published. And Mr. Justice Simons felt that this particular judgment had effectively changed the circumstances and had changed the circumstances in relation to the extension of lives of permissions. And Advocate General Kokot, in her opinion, considered that the extension of the duration of a development consent is in principle subject to the Habitats Directive. And Mr. Justice Simons said that while there was a question pending before the CJEU relating to the extension of consents and licenses and whether or not that triggered the Habitats Directive, and normally in those circumstances it wouldn't be necessary to refer more questions to the CJEU, he felt that the factual circumstances was quite different between case C41117 and the Friends case. And in particular, the main difference, or one of the main differences, was that in case C41117, there was actual physical works proposed to some of the nuclear power stations which were at issue in that case, whereas in the Friends case, there was no change in the works that were going to be carried out, and the decision was just an extension of the permission. Also, another factor which Judge Simons considered to be very, very relevant, and which is one which we'll see in the moment is coming out in the actual question which he referred, was the fact that when the board originally granted consent for the project back in 2008, the Habitats Directive wasn't properly transposed into Ireland, and the board hadn't carried out an assessment as would be required under Article 6.3. And he felt that this was another significant factor which would require, or which would mandate a reference to CJEU. Just in relation to the actual facts of the C411, and I'm not going to dwell on these too long, as I'm sure most of you will be familiar with them. They're also set out in the handout. But case C411 involved power stations in Belgium, and there was a Belgium law of 2003 which decided that there was going to be a cessation on the production of electricity from nuclear energy. So no new nuclear power stations were going to be built, and any power stations which were in operation were to be gradually taken out of service after they had been in operation for 40 years. And there were 2 nuclear power stations which were required to cease electricity production in 2015. But in 2015, the legislation was amended to allow electricity production to be carried out in a number of identified plants for a further 15-year period. Proceedings were then instituted seeking to annul the legislation on the basis that the legislation purported to authorise an extension of the activity, i.e. the nuclear power plants, without an EIA and without the relevant and necessary public participation. And Advocate General, in her opinion, invited the CJEU to depart from the previous case law in respect of the EIA directive. And as you'll all be aware, that in that particular, in the cases to date, and indeed the CJEU didn't follow the Advocate General's recommendation in this particular regard in relation to the definition of project in the EIA directive. But the CJEU has consistently held that the renewal of a permit to operate a project cannot, in the absence of works or interventions involving alterations to the physical aspect of the site, be classified as a project for the purpose of the EIA directive. And that's tied back into the definition of project contained in the directive. And Advocate General Kokot argued for a broader interpretation of project on the basis that it would be more consistent with the purpose of the EIA directive and also with the Aarhus Convention. Then with regard to the Habitats Directive, Advocate General Kokot said that, again, and this is something which is a recurring theme throughout CJEU case law, is that the Habitats Directive doesn't define what a project is, but that one can look at the definition of project in the EIA directive for the purposes of determining the concept of a project for the Habitats Directive. And she said that if the CJEU concurred with her view that an expansive interpretation should be given to project for the purposes of the EIA directive, then that would also follow through for the purposes of the Habitats Directive. However, the Advocate General also said, well, even if the CJEU doesn't go with my recommendation in relation to this broad approach or this broad interpretation of project, it still is the case that the definition of project in the EIA directive doesn't definitively delimit the concept of project under Article 6.3 of the Habitats Directive. and that the crucial factor under the Habitats Directive is whether the activity concerned is likely to have a significant effect on a European site. And on the facts of the case before her in case C4-11-17, there was a risk that protected areas might be affected because there might be an accident at one of the power plants, or the operating of the cooling systems could have an effect on fish in the local river, which was a protected site. And on that basis, irrespective of her view in relation to the definition of project under the EIA directive, Advocate General Cockett felt that the extension of the period of industrial production of electricity by a nuclear power station was a project within Article 6.3 of the directive, even if it wasn't a project under the EIA directive. So it was in this type of context where issues were arising in relation to the definition of project under the EIA directive and Habitats directive, and whether the extension of a project, albeit one which involved some works, required an assessment under the Habitats directive. It was in that context that the Irish High Court referred the questions in the Friends of the Irish Environment. And in total, 6 questions were referred by the High Court. Not all of the questions were answered. In fact, the court only felt it necessary to answer questions 1 to 3. Question 4 to 6 weren't answered. So if we just look at the questions, so I've broken them down like the court broke them down. They considered the first and second questions together, and then the third question separately. So the first and second questions, the first question was, does a decision to extend the duration of a permission trigger Article 6.3 of the Habitats Directive? And is the answer affected by any of the following considerations? And all of these considerations were based upon the facts of the particular case. And they were, firstly, that the original consent was granted pursuant to a national law which did not transpose the Habitats Directive properly. The consent made no reference to the Habitats Directive, nor did it contain complete, precise and definitive findings and conclusions capable of removing all reasonable scientific doubt as to the effects of the proposed works. The consent ceased to have legal effect on the expiry of the period with which it set for those works, and the works had not commenced. So were those particular circumstances, did they affect whether or not the decision to extend the permission triggered Article 6.3 of the appropriate assessment of the Habitats Directive? And again, as with Advocate General's opinion in case C4-11-17, the court first looked at, well, what is the project under the EIA directive? And again, the concept of a project within the meaning of the EIA directive can be taken into account in determining what a project is for the purposes of the Habitats Directive. And if an activity is regarded as a project within the meaning of the EIA directive, it can constitute a project within the meaning of the Habitats Directive, and that's established in various cases. And again, the CJU went back to the definition of project as contained in Article 1.2a of the EIA Directive, and said that, again, that referred to the work of interventions involving alterations to the physical aspect of the site. So again, the project for the purpose of the EIA directive involves works. But in the context of this particular case and in this particular application, which was to extend the life of a permission, which actually hadn't even been implemented, the CJU said that the decision to extend a period originally set for construction of the LNG terminal, for which works had not commenced, meets such criteria, so as it falls within the definition of a project within the meaning of the EIA directive. And so therefore that decision had to be regarded as relating to a project within the meaning of Article 6.3 of the Habitats Directive. So that was the first limb, whether or not the development was a project within the meaning of the Habitats Directive. But then the CJU went on to consider whether or not the activity could be taken as part of whether it was a single operation as part of a larger project, which would therefore be exempt from a new assessment procedure under the provision. And in respect of that particular issue, the CJU said that the consented issue relates to the same project as that originally authorised, but that in itself didn't mean that it wasn't subject to Article 6.3. And that was because the purpose of the consent is not to renew a consent for a recurrent activity which was in the course of operation, the purpose of the consent at issue was to allow the execution of the project, which hadn't commenced and which could no longer commence under the lapsed permission. And interestingly, the CJEU said that the consent related to a project irrespective of whether that provision had to be complied with when the original consent was granted. So the fact that the original assessment carried out under, say, in 2008 by the board when it originally authorised the LNG facility, and that consent had been taken out, had been granted under a procedure which had not correctly transposed the Habitats Directive, was not determinative of the fact that this time around that the project required an EIA, the extension of the life of the project required an appropriate assessment rather. The court also then considered whether the consent constituted an agreement for the purposes of Article 6.3. And as you know, Article 6.3 refers to the competent authority agreeing to the plan or project only after having ascertained that it will not adversely affect the integrity of the site. And again, in looking at the concept of agreement, the court referred back to the EIA directive and the concept of development consent under the EIA directive. And again, as you'll be aware, development consent under the EIA directive is defined as the decision of the competent authority which entitles the developer to proceed with the project. Again, on the facts of this case, the original consent had lapsed, work could no longer be carried out under that consent. And as the original consent had lapsed, it was therefore not altered by the consent at issue in the proceedings. So there was no question of this, the extension of the life of the permission altering the previous consent. In effect, the extension of the life of the permission actually replaced the previous consent. And ultimately, the CJEU concluded that the consent did constitute a new consent under the EIA directive, and consequently it was an agreement under Article 6.3 of the Habitats Directive. Therefore, there was a requirement in order to grant the extension of the duration of the permission to actually carry out an appropriate assessment under the Habitats Directive. That was the ultimate conclusion in respect to the first and second questions referred by the CJEU. In terms of the third question asked whether, if the answer to the first question is yes, i.e. whether or not an extension of the life of the permission triggered Article 6.3 of the Habitats Directive, what considerations is a competent authority required to have regard to in carrying out a stage 1 screening for such a consent? And in particular, whether or not is the competent authority required to take into account changes to the works or use as originally permitted? Is the competent authority required to take into account changes in the environmental background? Is the competent authority required to take into account changes in scientific knowledge? And is the competent authority required to assess the effects of the entire project, or is it just the temporal effect that is required to take into account? In answering this question, the CJEU said that account should be taken of any assessments which had been carried out for earlier consents, as that would avoid the same project being subject to several environmental assessments. However, it was stressed that in doing so, you can't rule out the risk that the consent will have significant effects on the Natura 2000 site unless the other assessments contained complete, precise and definitive conclusions. That there had been no change in relevant environmental and scientific data, that there had been no changes to the project, and that there were no other plans and projects that required to be taken into account. So the ability to rely on prior assessments wouldn't exist or wouldn't subsist if any of those factors were at play. And if you think about it, the consent issued in this particular case had dated from 2008. So even if an appropriate assessment had been carried out at that stage, there would probably have been questions in relation to whether any assessments carried out at that stage could still be relied on, especially in circumstances where there may have been other plans or projects in the vicinity which would need to be considered on a cumulative basis with the extension of the permission, or indeed there may have been changes in environmental and scientific data in that intervening period, which would undermine any earlier assessment which had been carried out. In this particular case, the CJEU held that the original consent was not preceded by an assessment under Article 6.3, so therefore it couldn't be ruled out that such a project might have a significant effect on the Natura 2000 sites, and that such considerations are such as to require consent to be preceded by an appropriate assessment. And such an assessment couldn't be a simple update of the assessment that may have been carried out previously. It must consist of a full assessment of the implications of the entire project. And that's the answer from the CJEU in respect to the third question, which I'll just leave up there for you to all ponder on. So I think the relevance of the case is that it deals with this idea of the extension of a planning permission where a planning permission had not been commenced at all, and whether or not in those particular circumstances one was really talking, I suppose people consider like an application to extend the life of the permission as almost like a rubber stamping mechanism. It used to be if you met the various criteria set out in section 42, you were automatically granted an extension of the life of the permission. However, now we're seeing that, particularly in cases where the development had never been actually commenced, that now there seems to be a requirement that an appropriate assessment will be required in the context of any applications to extend the life of the permission. I suppose one of the questions that remains unresolved is whether or not the appropriate assessment will be required in the context of a development where, in the context of an application to extend the life of the permission where the development had actually been commenced. In the Friends case, no development had actually ever been commenced. So this was in effect, the extension of the permission was in effect going to authorise the development to go ahead. It might be slightly different where you have a permission, you have started under that permission, and maybe you've completed a vast majority of the project and you're looking for a small extension just to finish off the project. There may be an issue as to whether or not the appropriate assessment would be required in that particular case. Ultimately, this might all actually become academic because, as noted by Mr. Justice Simons in his judgment, when making the reference to the CJEU in the first case, he noted that there have been amendments to section 42 of the Act, which have been on the statute book. They were introduced in the 2016 Act, but have yet to be commenced, which will effectively remove the right to extend an application for permission where an appropriate assessment will be required. For some reason, those particular provisions haven't been commenced. However, if and when they are commenced, that will result in applications no longer being possible where an appropriate assessment under the Habitats Directive is required for the development. It might be the case that that legislation or the implementation of that legislation might now be somewhat more imminent in light of the judgment in the Friends of the Irish Environment case, but I suppose we'll just have to wait to see. It might be something that we may be talking about in 2021 when hopefully we will all be back in Cork.